This video is on civil courts and the appeal routes, and it's an outline of the civil courts and appeal routes. Remember, it's an outline only. Now, the first thing to be decided is which court should the case be dealt with, and the two main courts that deal with civil cases are the County Court and the High Court, and the appeal courts are the Court of Appeal and the Supreme Court. Most cases tend to get decided outside of the court, so they're settled outside of court, and that tends to be through ADR methods, alternative dispute resolution methods, like mediation, negotiation. Now, if this isn't the case, because the case needs to go to court, then it will depend on the amount of the claim. The person making the claim is called the claimant, and the person being taken to court who the claim is against is known as the defendant. Now, with criminal courts, the objective is punishment, sentencing. It's the state against the accused, whereas civil courts are about disputes between individuals or organisations that need the court's assistance to help them resolve the dispute that they're unable to resolve themselves. Now, examples of civil disputes are some of these, for example, just a handful that I'm going to share with you. So think about this one: Sky Broadcasting claiming that someone has not paid for the services that they signed a contract for. And this is a common one: a claim for compensation for a car that now needs replacing due to the other person's negligence. It could be a car accident, it could be, sort of faulty workmanship. Another quite common example is for holidays. A claim against a holiday company for a holiday that doesn't live up to the standards that were promised in either the brochure or the online description. And another one that you'll be very familiar with: divorce cases. Litigation. Litigation is the process of having to take a case to court. Now, like I said earlier, many cases do get settled outside of court, and many people use ADR methods because there are a number of disadvantages of having to use the courts. They're more expensive, they take longer, court fees are high, lawyers' fees can be high, each party will be trying to win their case, and it can cause psychological trauma and stress for the parties involved. So if a case must go to court, then first things first, the parties need to begin with something called pre-action protocols. Prior to a claim being issued, both parties comply with pre-action protocols, and this can even help prevent a case from having to go to court. This is usually in a letter form and deals with things like the following from the claimant: how the claim arose, why the other party is at fault, and the level and type of injury. The defendant will have 3 months to respond. In this time, he or she will either, number 1, admit liability and pay in full, or 2, deny liability with reasons. Now, the amount of money involved depends on which court will hear the actual case itself. For a personal injury claim, if the amount being claimed is up to £50,000, then it will be heard in the County Court. If it's over £50,000, it will be heard in the High Court, the Queen's Bench Division, or the County Court itself. Now, for damage to property, the amount, if it is up to £100,000, will be the County Court, and if it's over £100,000, it will be the High Court, Queen's Bench Division, or the County Court. Now, if a claim is under £100,000 but it's complex, it can be heard in the High Court also. Now, the form that's going to be filled in by the claimant is an N1 form, and this is what it looks like. So you're seeing it on the screen now, both the front and back side of that form. And once the defendant receives it, the defendant can decide what they're going to do. Are they going to defend the claim? And here are the options that will be available to him or her. They could admit the claim and pay in full, and the case will be concluded. They could dispute the claim, which means they're going to defend it. This is option 2, and they've got 14 days to respond. Or they could ignore it. Now, if they do, an order in default can be requested by the claimant. And this means that the defendant will be required to pay the court costs as well as the amount that the claimant is requesting. Okay, so let's move on to the allocation questionnaire. Now, this is where the defendant has selected option 2, so namely they're going to file a defence. Then the court will allocate the case to the most suitable track, and there are 3 tracks which we'll look at in a moment. In order to determine which track is the most appropriate, both parties will have to complete an allocation questionnaire. Now, here are the 3 tracks, and it's very brief information about each one. You can be asked a whole examination question about the 3 tracks, so you'd need to know more. But the small claims track is for damage to property under £10,000, and where it's personal injury, it would have to be under £1,000. The fast track is between £10,000 to £25,000, and the multi-track is £25,000 or over, or complex cases that are below this amount. Now, the burden and standard of proof in civil cases, so if it's negligence, would be the claimant must prove all 3 elements of negligence in order to win his or her case. So duty of care, breach of duty, causation. And the standard of proof is on a balance of probabilities, namely whose case is the strongest. Let's now move on to appeal routes in civil cases. From county court decisions. Now, for claims under £25,000, so whether they were heard in the small claims or the fast track, will depend on which judge heard the case. So if the case was heard by a district judge, then the appeal will go to the next level judge up, which is a circuit judge in the county court. And if the case was heard by the most senior judge in a county court, which tends to be the circuit judge, then the appeal will go up to the High Court, to a High Court judge. Now, a second appeal can be made from the High Court to the Court of Appeal, but this is only with permission and if the case involves an important point of law, or if the party states that there is a really good reason behind why the appeal should be heard. Okay, so let's move on to appeal routes from High Court decisions. Now, a decision in the High Court is usually appealed to the Court of Appeal, its civil division, and in rare cases there may be a leapfrog appeal that is direct from the High Court straight up to the Supreme Court under the Criminal Justice and Courts Act 2015. Now remember, this is very, very rare, and the appeal must involve an issue which is of national importance or raises something of sufficient importance that warrants this leapfrog appeal. In addition, the Supreme Court does have to give permission. Now, here are 2 other things about leapfrog appeals. The first one is this, that the Court of Appeal is bound by a previous decision of its own, and it's believed that the Supreme Court may change the law, in which case leapfrogging over the Court of Appeal makes sense, or the case involves statutory interpretation, where they do have to look at the meaning of one or more words or phrases. And there are usually no more than a handful of leapfrog cases per year. Now, I do hope that you found this video useful, and remember, when it comes to the small claims track, you may have a question in an exam that is entirely about the small claims track or the fast track or the multi-track, in which case you will need to know more information. Or alternatively, you may have a question that's based entirely around alternative dispute resolution methods, in which case again you'd need to know more information about the areas of negotiation, mediation, arbitration, tribunals, conciliation, etc. Thank you for watching this video today.